Today I want to talk about LGBT rights and family law. 5 years ago, the Supreme Court issued an order in a case that we all know as Obergefell. That case said that every state had to honor the marriages of other states, even if they were between two people of the same sex or gender. What that essentially did was make marriage between same-sex partners legal around the country. I know that my wife and I were excited for this because we had already been planning our wedding, but we're going to have to go out of the state of Georgia to get a legal marriage, even though we were going to have our celebration here. That was no longer necessary under Obergefell. Unfortunately, even though that wonderful order in Obergefell, there have been a number of questions regarding other issues for same-sex partners. For example, if you had been together for a very long time before you got married, because it hadn't been legal before, what does that mean for a divorce in the future if you're going to divide assets? Similarly, if you had children together before Obergefell, what does that mean for the legal status of your children in the future? In order to address some of these issues, Georgia has taken a couple of steps. Right now, it appears that even if you don't do a second parent adoption, if a child is born in a same-sex marriage through artificial insemination, and you've done all the proper paperwork and it is an unknown donor, that child will be the legal child of both parents, regardless of the biology and who the child is biologically related to. However, many couples, like my wife and me, have gone through the extra step of doing a second parent adoption for the non-biological mother in order to just make sure that the kids have all of the rights necessary. Because unfortunately, in some states like Alabama, people have been successful in questioning the parentage of another parent, even within the bounds of a marriage. Additionally, we have found that there are a lot of couples who have formed families without the bonds of marriage and without a legal adoption. And so in order to protect those children and the rights of those parents, Georgia entered a law last year that allows caregivers who have stood in the place of parents for the children's whole lives to attempt to gain access to custodial rights that would otherwise be able to be awarded in a divorce or separation. In those cases, the parent that is petitioning for custodial rights has to show that they have taken on the role of a parent for most of the child's life without any expectation of remuneration or payment. That means a nanny, even though they've taken care of a child since they were born, can't get rights. But possibly a step parent or a same-sex partner who has been in a child's life and has taken care of the child and provided financial support, that parent may be able to get visitation and custody. This is going to bring up some really interesting issues of children having three custodians or three parents. It's going to open up some interesting issues of live-in boyfriends or live-in partners when there wasn't really the intention that they become a parent, but that person may now have the right to sue for custodial rights. My biggest advice is to talk to an attorney. It's especially important to talk to an attorney if you have had a child with another parent, but there was a known donor and you didn't do paperwork beforehand. If you are not married, or if you got married after the child was born, you should really talk to an attorney to make sure that your rights are up to date and written out and entered as an order by the court. Otherwise, if you separate from a person, you may find that you don't have any custodial rights when you thought that you would.